Lesson: Sale of Goods and Services Agreements. The sale of goods and services agreements are fundamental components of commercial law, serving as the backbone of countless transactions that occur every day. These agreements establish the terms under which goods and services are exchanged, and they are essential for delineating the rights and obligations of the parties involved. Professionals dealing with these agreements must possess a nuanced understanding of their structure, terms, and the potential pitfalls associated with their execution. This lesson delves into practical tools, frameworks, and strategies for drafting, negotiating, and enforcing sale of goods and services agreements, ensuring that practitioners are equipped to handle real-world challenges effectively. At the core of any sale of goods and services agreement is the need for clarity and precision. A well-drafted agreement should unambiguously identify the parties involved, the goods or services to be exchanged, the price or consideration, and the terms of delivery or performance. One practical tool for ensuring clarity is the use of a standardized template that can be adapted to suit specific transactions. Such templates serve as a checklist, ensuring that no critical elements are omitted. However, while templates are useful starting points, they should be customized to reflect the unique aspects of each transaction. Customization requires a deep understanding of the specific industry norms, regulatory environment, and the parties' objectives. In crafting these agreements, legal professionals must also consider the implications of the Uniform Commercial Code, which governs the sale of goods in the United States. The UCC provides default rules that apply unless the parties explicitly agree otherwise. For instance, under the UCC, the risk of loss passes to the buyer when the seller has completed delivery obligations. However, parties can modify this rule through explicit contract terms. Understanding the default provisions of the UCC and how they can be altered is crucial for ensuring that the agreement reflects the parties' true intentions. A critical component of sale of goods and services agreements is the management of warranties. Warranties are promises that certain facts about the goods or services are true, and they play a vital role in allocating risk between the parties. There are generally two types of warranties: express and implied. Express warranties are explicitly stated in the contract, while implied warranties arise by operation of law, such as the implied warranty of merchantability and the implied warranty of fitness for a particular purpose. Professionals must be adept at drafting warranty clauses that either enhance or limit these protections, depending on their client's position. The use of disclaimers and limitations of liability can protect sellers from unintended warranty claims, but these provisions must be carefully crafted to be enforceable under applicable law. Negotiation is another critical phase where legal professionals can add significant value. Effective negotiation requires a balance of legal acumen and interpersonal skills. One effective strategy is the use of a BATNA, or best alternative to a negotiated agreement, which involves understanding the best outcome each party can achieve without an agreement. By clearly identifying their client's BATNA, negotiators can better evaluate offers and make informed decisions about when to accept a proposal or walk away. Additionally, understanding the other party's BATNA can provide insights into their motivations and potential concessions. Enforcement of sale of goods and services agreements can present challenges, particularly when disputes arise. An actionable insight for professionals is the inclusion of clear dispute resolution mechanisms within the contract. Options such as arbitration or mediation can offer more efficient and cost-effective resolutions compared to litigation. Including a choice of law and forum selection clause can also provide predictability regarding the applicable legal principles and the location of any legal proceedings. These clauses should be drafted with care, taking into account the jurisdictions involved and any potential conflicts of law issues. To illustrate these concepts, consider the case of a manufacturing company entering into a contract with a supplier for the purchase of raw materials. The parties used a standardized template as a starting point, but they made several key modifications to address industry-specific concerns, such as quality control standards and delivery schedules. The agreement included an express warranty regarding the materials, compliance with certain specifications, and a limitation of liability clause that capped the supplier's damages in the event of a breach. During negotiations, the manufacturing company assessed its BATNA, which revealed that although there were alternative suppliers, switching would incur significant time and cost. This assessment informed the company's negotiation strategy, allowing it to prioritize certain terms while making concessions on less critical points. Pause. Statistics underscore the importance of these agreements in facilitating commerce. According to the International Chamber of Commerce, global trade in goods and services reached $22 trillion in 2020, highlighting the vast scale at which these agreements operate. This underscores the necessity for well-drafted contracts that can withstand scrutiny and enforceability across borders. Moreover, technological advancements have introduced new dimensions to sale of goods and services agreements. E-commerce and digital services require professionals to consider additional factors such as data privacy, cybersecurity, and intellectual property rights. Frameworks such as the General Data Protection Regulation in the European Union impose stringent requirements on how personal data is handled, necessitating that contracts involving digital services address these legal obligations. Similarly, the rise of smart contracts, which are self-executing contracts with the terms directly written into code, presents both opportunities and challenges. While smart contracts can increase efficiency and reduce the risk of human error, they require a robust understanding of both legal and technical elements to ensure that they function as intended. The integration of these technological considerations into sale of goods and services agreements represents a significant area for professional growth and development. As technology continues to evolve, legal professionals must stay abreast of new developments and continuously refine their skills and knowledge. In conclusion, sale of goods and services agreements are complex instruments that require careful drafting, negotiation, and enforcement. By utilizing practical tools such as standardized templates, understanding the implications of the UCC, managing warranties effectively, employing negotiation strategies like BATNA, and incorporating dispute resolution mechanisms, professionals can enhance their proficiency in this critical area of contract law. Furthermore, staying informed about technological advancements and their impact on these agreements is essential for addressing the challenges of the modern commercial landscape. By mastering these elements, legal professionals can provide valuable guidance to their clients, ensuring that their agreements are robust, enforceable, and aligned with their business objectives.